the Divorce Education Series presented by Findling Law. I'm Daniel Findling with thedivorceguy.com, and in this topic we're going to talk about how to settle a divorce case. Let's get started. Alright, it's important to note that over 95% of all divorce cases settle. So how do we get there? And why do we get there? Well, there's certain benefits and risks or costs associated with settlement. Of course, it's more civil, right? It's less taxing on the family if you're able to settle a case. There's a chance that you and your spouse can have a relationship afterwards. So often we hear about how a divorce tends to destroy families or makes it impossible to move on after a divorce. Oftentimes, there's no such thing as a civil divorce, but civility could be important. It clearly can be less expensive. Trying a divorce case can be very expensive. So by settlement, you save legal fees. You also gain certainty or mitigate risk because you control the outcome. You decide along with your lawyer and the people that are working with you in your camp what the outcome of the case is going to be by agreement versus having a judge make the decision. But it also requires some things. There's some risks involved. The first is that it really does require trust. Now, what I mean by trust, this could be actual or perceived trust. In order to settle a case, the parties must believe that they trust each other, and that's very difficult when you're in the middle of a divorce, and oftentimes that is broken down. How can I trust him, or how can I trust her? But we have to understand that what I mean by trust here is that we trust that everything is on the table, that we understand everything. Now, another risk involved with settling a divorce case, of course, is a hidden assets. What I mean by that is if you have a business or somebody has a business that has a cash aspect to it, and you're asked to trust them, well, it's often difficult to settle a case when somebody's saying, I only make $22,000 a year, but they're living a lifestyle that says something quite higher than that. So if there's a cash aspect to a business, it becomes a lot more difficult to have trust. It really goes with the first requirement or the first risk that we talked about. Of course, agreement on some issues like custody or parenting time can be difficult. So, with settling a case, it often becomes an impediment to settle if you can't agree on some of the key issues, right? Who's going to have parenting time? What's custody going to be like? And then, of course, probably the greatest risk of all that sums up everything that we're talking about here is how do you know if it's a good deal? What's on the table? You've heard an offer for a settlement of your divorce case. Should you take the offer? What's the cost-benefit analysis that goes on? And really, I'll tell you right now, you have to ask, well, what is the risk if I go to trial versus accept the benefit? And we'll talk a little bit more detail about what that actually means and how to settle. All right, well, first thing, there's some institutional reasons why we settle. It's built into the system. There's statutory waiting periods. If you have a divorce with minor children, it takes 6 months to get divorced. And during that 6-month time period, that's time to build trust, time to have a dialogue, to have conversations, to see if you can reach a settlement. Because after all, you're waiting that statutory waiting period. With a divorce without minor children, it's generally a 60-day waiting period. But still, the statutory waiting period is an institutional sort of encouragement for settlement. Most courts will order mediation or facilitation. That is, a third-party neutral lawyer sits down and listens to the position. What happens at mediation is that the lawyers write a position statement. These are the facts of the case. These are the assets. These are the liabilities. Here's what Michigan law provides. Here's our proposed settlement. And maybe one side has unrealistic expectations of how the case should be settled. Well, the mediator's a neutral, a third party, generally has an understanding of the judge, of how he or she may rule in a specific case, and will tend to try, these good mediators, to get you to come together, to save money, and to settle your case. Judges also play a role, I should say, in this, and that is they set a settlement conference. Part of the formal process of a divorce is to have a settlement conference, and oftentimes in many courts, judges will use a settlement conference as an opportunity to settle the case. Sometimes it's just a day to get dates when you go to court and they find out where are you, what is it that we need, okay, let's set a trial date. But many judges will take lawyers into chambers, will ask questions on the record, and play an active role in settling the case. And then finally, this risk of trial. Trial can be expensive. Trial is dangerous. And courts know that. And you know what they do often? They adjourn it. That is, they make you show up for a trial date, and you sit there for 8 hours waiting for your case to be heard. And there's nothing that you can do except talk and try to settle the case. So there is this institutional encouragement of what we just talked about and how courts try to get you to settle cases and why so many actually. All right, so how do we actually do it? We know that we want to settle cases, that is, if at all possible, save money, right? Emotionally be happier, maybe have a relationship with your spouse, but how do we do it? Well, you have to build trust. What I mean by trust is that if the parties don't trust each other, that the nature and the extent of the estate has been disclosed, and that everyone understands what there is, you're never going to settle the case. Now, from a strategic standpoint, that could be perceived trust. It doesn't have to be actual trust. Oftentimes in settling a case to get a good deal, maybe you're skirting the issues a little bit, or maybe not answering every question the way that you should answer the question. But if it fosters and encourages settlement and it builds trust, then let's do it. Conduct discovery. If you don't conduct discovery, if you don't understand what is the nature and the extent of the estate, what is there to divide, under oath, subject to the penalties of perjury, you're never going to know if it's a good deal. Because even though somebody says, trust me, discovery is a way to discover if what they're telling you is true. What are the assets? What are the liabilities? What was that credit card used for? How much is that business actually worth? You build trust by not only asking the individuals directly, but also by conducting discovery, like interrogatories, subpoenas, requests to admit, or even confidential disclosures of what your assets and liabilities are. You must set realistic goals and stick to them. Now, this happens typically at the beginning of the case, and it can evolve. So often, lawyers try to overpromise something to clients just to get them to sign up, or for whatever other purpose that they may have in mind. But if one party has unrealistic goals or expectations, they're inevitably going to be disappointed when it comes time to settle a case, because it's completely different to what their expectations are. So you rely on your lawyer to help you set reasonable expectations and goals, and then don't waver from them. If they're primary goals, if they're key, if they're important, stick to them. You also have to rely on your lawyer, not only in setting goals, but also what the law provides. Now, this may seem contradictory, but to settle a case, often you have to say we're going to trial. And we'll talk about why in just a few moments. You cannot be afraid to go to trial. It makes it very difficult to settle a case if you are afraid, because you will be taken advantage of. All right, what did we talk about building trust? We talked about it just a moment ago. The parties must trust each other. So we asked, what is the nature and the extent of the estate? What is it that you have? Why? What do you want to do with the children? I don't trust them. I'm uncertain. So we conduct discovery. All right, what do I mean by discovery? Well, those interrogatories, those requests to produce, maybe a subpoena for court documents. But without trust, it is difficult to settle. If you think that you have trust, discovery has been conducted, and you realize that someone's lying, then guess what? It's going to be very difficult to settle. And when we talk about discovery, I really mean what's on the screen here. You have to understand the nature and the extent of the estate, what there is to divide, before you can talk about a division. So often people come to our office and say, we want to settle the case, this is it. Well, what are your assets and liabilities? I don't know, but my husband told me, or my wife told me, this is what they are. Discovery is the process by which you understand what there is to divide, and then your lawyer can tell you how it should be divided. Discovery also provides for the penalty of perjury. You go to jail if you lie. What I mean by setting realistic goals and stick to them is that unrealistic goals makes it difficult to settle. If you think that you're going to get 100% of the marital estate because somebody has committed an extramarital affair or had extramarital sexual contact, that's not likely to occur under Michigan law. Sure, there can be a penalty for fault, but it doesn't mean that that penalty is 100% of the asset or 100% of the liability. You must rely on your lawyer to understand what realistic goals are, and when you set them, stick to them. You can bend, but don't. Relying on your lawyer's judgment is so important in settling a case because your lawyer should tell you what the law provides, and even more importantly, your lawyer should tell you what he or she believes the judge will do. So when you settle a case, there's an offer on the table, or maybe you make an offer. How do you determine what that offer should be? You understand what there is to divide. What are the assets? What are the liabilities? What does Michigan law provide? What would the judge do? How much is it going to cost me for the judge to make a decision like that? And do a cost-benefit analysis. Is it a good deal or is it a bad deal? And when I talk trial, I do so for a reason, and there's one word. That word is leverage. Leverage settles cases. If people don't have an uneasiness that maybe they'll do worse if they don't settle, or maybe it'll cost them so much money and that the return won't be that great. Leverage settles cases. How do you obtain leverage? You say we're going to trial. And don't be afraid to go to trial, because if you make a threat in settlement, this is our bottom line, and then you waver from that bottom line, then you've lost all credibility. But if you say you're going to trial and you actually proceed, more cases settle at the judge's doorstep than you'd ever imagine. The leverage is there's fear. When a judge adjourns a trial date or makes you sit there, now everything is percolating and you settle a case. So you can't be afraid to go to trial when settling a case, because that's how you get it done. Now it's inevitable that you're going to have questions. We want to be here for you. You can call us at 877-YOUR-FIRM. The number's here. Of course, you can email me at daniel@findlinglaw.com or visit us at thedivorceguy.com. I want to thank you for your time. Hopefully you've learned something. We want to help you manage your situation. Call us, email us, let us sit down, talk, set up a consultation. We can settle your case, and if necessary, we can try it too. Thanks for listening, and I'm wishing you a good day.